My name is Sean Willick. I'm the safety training manager here at ARA. I'm joined with Kevin Gurn. Do you want to introduce yourself?
Sure. Kevin Gurn, Vice President of, I always want to say safety and education, but that's not the case anymore. Vice President of State Advocacy, Government Affairs, and Risk Management.
Perfect. And then our moderator today is Grace Nelson. She is the Director of Education, and she will also be fielding our Q&A portion. If you guys could, any questions that you have, submit them to the chat, and we'll get through as many as we can once we get to the end. We will have a designated Q&A portion at the end of this. All right. I mean, do we want to give people another minute or just want to get right into it? All right. We're going to get right into it. So today we're going to be talking about updates to the OSHA regulations that have going to take place, things that have taken place, and just some stuff that you guys need to know. So, on here, some things out of my way. All right, so we're going to be talking about specifically 4 things, and the first one's going to be the updates to the injury and illness record keeping regulation. We're going to be talking about the proposed injury and illness prevention rule. And we're going to be talking about OSHA's new walk-around rule, as well as the Loper-Bright Supreme Court decision. These are all things I think are pretty relevant and that would be beneficial for the members to know. So first things first, we're going to dive right into the injury and illness regulation. So just some background on this. So the history of this goes back to about 2016. In 2016, OSHA promulgated a rule for the electronic submission of the 300, 300A, and 301 logs by employers, but it was delayed, and 300A and 301 was not required to be submitted. In 2019, OSHA revised the requirements to only submit Form 300A for certain companies, and they proposed an update to the rule in March of 2022, and that rule update did go into effect at the beginning of this year. So the updates are that employers in specific high hazard industries with 100 or more employees must electronically submit all 3 of the logs, 300, 300A, and 301 logs. And this does not directly impact the rental industry, but numerous members may still need to submit these forms. So depending on your business and the various NAICS or NIAT codes, it could be a relevant update for you.
Sean, you've been at ARA for a little while now, and you know some of our members and the businesses that our members have. What would be some examples of some members that you could see that this rule would affect?
So yeah, so there's actually an appendix that is, if you look up this change, you can find an OSHA article that talks about what business NAICS codes are specifically targeted for this, and warehousing and storage would be the one that I'd be most concerned with. And I know that we've had several members this year hit with OSHA inspections because they do have warehouses. They do have storage facilities. They have distribution centers, which can be seen as storage and warehousing centers. So that would be the one that I'd be concerned with most. If you do have a business that has storage facilities, warehousing facilities, you could very well be expected to submit all 3 of these forms. Okay. Yeah, if you have 100 or more employees. So we'll move on here. So next steps, just kind of piggybacking right off that conversation, check if your company is impacted by this. You can do that by going to OSHA.gov, looking up the new rule, and right in the regulations, they'll have an appendix that lists all of the NAICS codes. And if you are impacted by that, or you think you might be, it'd be a good idea to start recording those if you're not already, and then obviously submitting those. You do need to keep all of those logs on file for 5 years. And if you have a workforce that exceeds 20 employees, you'll need to submit the 300A log for the prior year by March 2nd, regardless of whether or not this regulation change affects you.
And the 300A logs, the 300 logs and those items, those are forms that you could download from the OSHA.gov website, correct?
Yep, you can go to OSHA.gov and you can actually just Google OSHA 300, 300A, 301 logs, And it'll be right there. They'll have a PDF fillable copy or an Excel copy that you can download. And that's going to be where you want to keep all of your accident investigation information. It's going to have a summary, and it's going to show your TRIR and DART rates and, well, lost time rates as well.
Perfect. And in addition to that, members could potentially even reach out to their workers' comp insurance carrier, and they would probably be able to assist them with those forms or get them copies, et cetera.
100%. Yeah.
Perfect.
And with the PDF fillable copies, it does come with very detailed instructions. So you can actually go on there, download that PDF copy, and it'll show you exactly how to use those forms. So that's another avenue as well.
Perfect.
All right, moving on. This is a big one that I know a lot of people are looking to get information about. This is the proposed heat injury and illness prevention rule. So the rule itself, so the heat injury and illness prevention rule, or HIIP, is a proposed regulation that's currently undergoing the public review period. This rule will establish obligations for employers to create safeguards for their workers from heat exposure, whether it be created from indoor means or outdoor means, obviously the sun. So the anticipated implementation date is going to be sometime at the beginning or middle of next year. The complete text is currently online, so that way you guys can go on and look at it.
And because this is a proposed rule at this point, it's not actually a rule, but it's something that we could see coming down the road so that we can prepare for it.
100%. Yeah, this is it's far along in the promulgation process, so this is obviously something that it might undergo some changes, but we can definitely see it being promulgated sometime next year.
Is there currently any kind of a template or a plan that members could utilize to draft their own plan or their customized own plan? Is there anything currently out there available, or is that something that would be coming?
So yeah, so and if you're familiar with OSHA, they will oftentimes recommend templates for their programs that they think are good and they would like you to use. Because this is a proposed rule and it is subject to change, they have not put out any recommendations. But once that rule is finalized, ARA will be producing a templated program that members can use that'll be rental specific and they can customize to fit their workforce.
Great.
So the main points here on this, so employers with 10 or more employees are going to be required to establish and keep a written heat injury and illness prevention plan, HIIPP, which is kind of what we were just talking about. This plan should include identifying the types of work activities conducted. It should be tailored to outdoor and mobile work environments. So this is going to be especially big in the tent and event industry. Obviously, they're going to all sorts of different types of environments, and their busy season is typically during the hotter months. So this would be really impact them quite a bit. Identify specific work areas for indoor activities. So this is going to be the areas that are going to be very hot, either due to environmental factors, such as just being in an unconditioned AC or a non-conditioned warehouse that is lacking AC, especially like down in the southern states during the month. During the summer months, it could be very hot in there. And it's also going to want you to outline a monitoring strategies for each of those identified work areas.
So this really impacts not even just the event side, but if you think of the equipment side where, technicians are out on job sites, working on equipment out in the sun and the heat.
Yep.
Doing repairs out there, lifting heavy loads or, doing the things that they do every day to maintenance and preventative maintenance on the machines. That's going to be something that's going to affect the equipment side as well.
Yep. Or any any type of hot work where it might, like any sort of cutting or welding or brazing, it's also going to be impacted here because you can quite foreseeably see that this is going to get you can create a work environment, especially during the summer months, if you don't have a air conditioned service area where it could get very hot. And they do cover in this regulation the nominal trigger points, the high heat trigger points, and I think there's the very high heat trigger points. I want to say it's 80, 90, and 100 degrees. But those are kind of arbitrary numbers, and they do allow for the business owners to set their own trigger points, but they don't really give they just say you can do it, but they don't give any guidance on how to. So if you go
away from their trigger points and it turns out bad, you could almost be exposing yourself to additional risk.
Right.
So I don't know that I would go that route, but it is an option. They also require involvement of non-management employees, and it's necessary for creating, executing, and revising the HIPP. So what that basically means is you have to gain input from non-management employees at all levels. Whether you're initially creating, whether there's a reason that you need to revise it, or during the implementation process, you have to include their input and gain their feedback. And how you do that and how you record that and how you make sure that that happens to a satisfactory level, they don't really outline that either.
Yeah.
So that's another interesting
Well, with,
point.
with good safety programs across the board, it's always good to get that involvement of the employees that are actually, doing that job or experts in that area or field.
Yeah.
To get their buy-in on the safety aspect or whatever proposed, policies you're looking to put in place, but also just to have that expertise to
Yeah.
weigh in. That's great.
100%.
Just continuing on here, so non-management employees should receive training tailored to their literacy level. I'm not entirely sure what they mean by that. I imagine they mean that it has to be understandable to all employees. You can't use 25-cent words that are industry exclusive. Like two safety professionals like ourselves, we can use a lot of language that might go over some people's heads because they're just not tuned to the language that you and I, the shop talk that you and I speak all the time. But I think it just means that it has to be understandable to the base level employee. And it has to include a Q&A, question and answer session, so that way there's full understanding.
So you have that knowledge check to ensure that the employee actually understood and received the information.
Yep.
Okay.
Yeah. Training should be conducted upon hiring, but also whenever conditions change, after there's a heat related incident, and also annually. So you have to do those trainings annually as well. Training should be delivered in the language spoken by the individual.
Sometimes there's some confusion and I think that phrase right there alone might add some confusion. So is there a way that maybe you could clarify that point just a little bit more so our members understand?
Yep.
So that doesn't necessarily mean that, like, if somebody has a first language that's not non-English, that you have to provide it in that language. If they can speak, read and write English, right? Even if they prefer to speak, read and write Spanish or French or whatever, you can deliver it in English provided that they can understand it.
Okay.
Right. And that kind of goes back to the literacy level as well, right? If somebody can speak English, but they can't read or write it, you're going to have to give it to them in that language that they can read, write, and speak. But yeah, so you're going to have to deliver that in that language that they can intelligibly understand in every format.
Gotcha.
And then also this plan requires that a heat safety coordinator and HSC must be identified in the plan, and that supervisors must undergo training on intervening in heat related illnesses and responding to heat emergencies. So that's also something that is new. This is one that I know a lot of employers have been kind of worried about, been very controversial. This is the new walk around rule.
So the previous rule, which was 29 CFR 1903.8C, which you can still look that up if you look that kind of address up that regulation number, you will still find the rule. So the previous rule basically stated that both employers and employees were entitled to have representatives accompany them during an OSHA inspection. Okay. The initial rule basically stated that employee representatives, apart from specific instances where somebody with a technical degree of knowledge, like a safety engineer or an industrial hygienist, that representative usually had to be an employee of that company. And again, the only exception to that was when a high degree of technical expertise was necessary. The new rule basically states that the representatives authorized by the employees can be a third party or an employee. So it can be any non-employee third party. And
employees have various choices for that. Obviously, it's kind of opened it up, but they no longer need to have those formal credentials. That third party employee no longer has to be an industrial hygienist or a safety engineer. It can be quite literally anybody that they agree would want to they'd want to have be the representative. That being said, the third party representative approved by the employees might be essential. They might have a comprehensive, and this is kind of right from the language, an efficient physical. Might be essential for comprehensive and efficient physical inspection of the workplace due to their expertise, skills, or experience. So what that kind of suggests is that individual who they select would have to have some sort of knowledge of what's going on in that workplace or some sort of knowledge of that industry, but it doesn't actually specify that they have to be anybody of any credentialed background. The reason why this is getting to be a little bit more controversial is because if there's an OSHA inspection, employees have the option to designate a third party, right? And as long as the inspector deems it necessary, that third party could be a union representative, it could be a workers' rights representative, or it could even be a competitor, right? And that's where a lot of employers and a lot of representatives of employers are kind of ringing the bells saying, hey, what OSHA just did was gave a license to the employees to have any person who could be an outside antagonist come waltzing through my facility. And if the OSHA inspector says it's okay, which they will, because they're not going to want to get in they're not going to want to get into the means of that. They're just going to say, as long as you don't impede my investigation, you can absolutely come along. They could just have anybody that they want come walking through. And that could be very problematic for employers as far as trade secrets or just opening up yourself to additional liability from competitors or union reps or workers' rights advocates. It could be a big mess.
So I can almost kind of hear the members that are on this call right now, watching this, reviewing this content, listening to what you're saying, and, to actually think about it from their perspective and having been in their shoes previously, the basis of that rule that is in place now, that's already in place, basically that change allows any third party potentially to come walking through my place of business that would be another set of eyes and potentially aid in the OSHA enforcement officer's investigation of my facility, which if they are a competitor, if they are a union rep, if they are, some other external entity, could really cause havoc and create additional problems for me as a business owner.
Yeah.
So on that, I'm privy to a lot of discussion and a lot of comments that I've heard around this rule that again is in place, right?
Yep.
It's not a proposed rule, it's a rule.
Yep.
There's definitely potential for litigation around this.
Yep.
I've seen some different articles around litigation being, drafted and things being put in place or discussions held. Where do you see, from your perspective, where do you see some of this headed with this current rule?
So it all depends on there are several federal lawsuits, to my understanding, that have been filed on behalf of employer groups around the country regarding this, and the argument just is that hey, you basically just given a license to have, and by the way, there is no restriction on the amount of third-party representatives that they could potentially have. So you could be in a situation where you've just given license to my employees to have a parade of outside antagonists march through my facility, and there's not a thing I can do about it. They're going to argue, and they are arguing, that is well outside the congressionally given authority of OSHA, right? And that's the ultimate argument. And actually, this kind of goes into the next topic we're going to talk about, but I could foresee a very real, situation where this gets struck down in the federal courts. Now, don't take that home. Obviously, don't take that as, as a matter of fact that it will. It could also go the opposite way. It depends on to what level of the courts it goes. And it depends on, what those judges or that judge, says about it. But there could very well be a situation where this goes away. There also could be a situation where it stays. Either way, it would be really beneficial for our members to maintain a pulse on this and just maintain an eye on it. And also make sure that they themselves are protecting their business by being compliant to OSHA regulations, doing the necessary documentation and record keeping that is necessary, and just being prepared for an OSHA inspection if one were to occur.
And keep in mind, again, this is already a rule that's in place,
Yep.
and the wheels of the government don't necessarily turn quickly.
No.
So if there would be a change, it's not like it's gonna happen today or tomorrow.
Yes, no, yeah. All right, moving on here. So yeah, next steps, be prepared. Go online and read that should be the rule. It's not a proposed rule. That is actually the rule. Start implementing these practices. Now, I think this one actually this should have been at the end of the heat injury rule. Sorry, guys, this one got out of place somehow. We're gonna move right on then. So Loper Bright Supreme Court decision. We're gonna move on to this. So this one's gonna be a little bit higher level. This is a little bit more of a discussion on some of the legal aspects of the Supreme Court decision. So in order to understand the Loper Bright Supreme Court decision, you really have to understand a previous decision back from the 70s called Chevron deference. Chevron deference was a legal precedent that utilized that was utilized to assess regulatory agencies' authority in interpreting their own statutes. So what does that mean? Basically, it gave the regulatory agencies like OSHA, EPA, DOT, FMCSA, these different regulatory agencies, it gave them the ability to interpret the acts of Congress that created them in order to create regulations. Okay, so basically they were able to read the statutes that created them and say, yep, all regulations fall underneath the authorities given to us in that in those statutes. There were two considerations that courts used in order to determine whether or not their regulations really were, and that was if the regulations were in line with the statutes themselves. So for instance, OSHA couldn't make a regulation that categorically made the workplace less safe, right? And also if the agency's interpretation was reasonable, right? And why that's important is because the court could actually have a different interpretation, but they would defer to the agencies because of their technical expertise. Okay. So that was what was in place prior to this Supreme Court decision. So what changed? So this rule, which happened, I think it wasn't last month, I think it was the month prior. I think it was the month of June. This came down. The ruling granted the courts the authority to interpret the provisions of a specific regulatory law, such as the OSHA Act of 1970. So what this basically means is now it's going to be up to the federal courts to decide whether or not an agency's regulations align with the authority conferred to them by the statutes, by the acts of Congress that created them. So basically, this just gives the power to interpret laws back to the courts, where arguably it should have been the entire time. OSHA, compared to other regulatory bodies, heavily depends on interpreting its own statutes. It has consistently advocated for the application of Chevron deference. And the reason why is because the OSHA Act of 1970 is rather vague. It doesn't really get into the specifics of what OSHA can and can't do. It just says this is what it ought to do. This is what it's going to do, but it doesn't really get into and it can create regulations around PPE or fall protection. It just says it has, it's vague. It's very vague compared to like the Environmental Protection Act or something like that. So what this means for our members is that existing laws and regulations will remain unchanged. This does not overturn anything. The OSHA, the regulations that were promulgated by OSHA during the use of Chevron deference, that was seen as a acceptable legal what's the word I'm looking for? Application of theory, I guess. So nothing's actually changed. States with state-operated OSHA programs will probably they'll probably experience limited impact. unless they themselves adopt Chevron deference, which many states probably will, some states won't. But if you have a state that has its own OSHA, you're probably going to see very little impact unless they're adopting federal regulations. And then if those federal regulations change, obviously the adoption of those will change as well. Also, Congress is going to have to provide clearer guidance in their statutes. So when they promulgate rules, they're going to have to make sure that they are easily understood and that they're not vague. But what this does do is it introduces a new avenue of defense for challenging OSHA citations. So if you have the means to challenge OSHA at a high level and you're willing to pay the price of doing that, you could argue, and if your legal counsel agrees, you could argue that, hey, this citation is outside of the congressionally appointed authority of OSHA. And, obviously that would go to the Supreme Court, or not the Supreme Court, but a higher court, federal court, and then a judge will determine whether or not that is the case. So that this is a new avenue of defense for challenging OSHA citations. So it's going to make, and also it'll make the process of OSHA promulgating regulations much slower, which it's already not fast. So, so yeah. The biggest thing we can do is, be prepared. Obviously, we want to make sure that, we have all the necessary training and that we're compliant. So the first thing we can do here is utilize Run on You. We have a bunch of certification programs, a bunch of safety programs on there. We have a bunch of education surrounding OSHA itself and specific topics and areas. So obviously we would want our members to utilize that. And then also members need to take a good look at what they have as far as policies and programs that are in place, and make sure that they are compliant and that they have the correct policies and programs in place.
So it might create an opportunity for members to just kind of go back, take a look at some of their policies and procedures, do a little bit of an audit and a spot check just to make sure that they're compliant at this point.
100%.
Gotcha. Okay. And it sounds like we're probably going to, ARA is probably going to release a one-page info sheet on the walk around rule and the heat injury prevention proposed rule.
Yep.
Just so there's some additional information, bullet points.
Yep.
So members can understand that as well.
100%.
Okay.
Like I said, that one slide that was a little bit out of place.
The best thing you can do for that proposed rule is just be prepared. Go online, read the text, make sure that you are understanding what the potential implications for your business is, and start putting that plan together. Start putting those things together, so that way, when it does eventually come around, you're in front of the 8 ball, not behind it.
Right. Okay. And at this point, it looks like we're gonna
Go into the
go over
Q&A.
and see if there's any questions that may have come up at this point. And if you do have a question, as far as some of the topics that we've covered today, I guess at this point we'd ask that you put them in the chat, or is there an opportunity to unmute?
And they can also unmute as well.
So if you'd like to unmute and ask a question to us about some of the things that we've covered, or maybe something that has sparked another conversation topic or a piece that maybe you'd like to bring up, we have a few minutes here that we could bring up a couple of questions and answer some Q&A live. So you can either type it in the chat or unmute and go ahead and ask a question, and we'll pause for a couple minutes here and give everybody an opportunity.
No questions yet, but one of my questions, learning about OSHA and all of these updates, is where's, other than ARA and our safety consultants, where's the best place to get the most update information and accurate information? Because I feel like as a government entity, there can be so much information all at once, and it can be overwhelming, especially if somebody's new into their business or just hasn't even thought about these things. But what's some advice for somebody who may be feeling a little bit overwhelmed with all the information of where to find it?
Yeah, OSHA.gov is definitely the best resource. You can also sign up for their email list, and they will send out updates and things like that. Also, organizations like the National Safety Council or the American Association of Safety Professionals, those types of organizations, they will usually, especially on their social medias like LinkedIn, Facebook, Instagram, they will have really good contextualized updates on OSHA changes as they come out, and usually they'll provide a little bit more plain language explanation than what OSHA will provide in certain instances. OSHA does a pretty good job of trying to give a down-to-earth explanation of some of their requirements themselves. So you follow some of those organizations up to and including OSHA, you should be pretty informed, right? The biggest thing is just maintaining a consistent pattern of actually going and looking at those emails and checking those articles and reading those things. Because if you just sign up for the email list and then never read anything, you're not helping yourself. It really is a knowledge is for the seeker situation.
And keep in mind, members do have access to, Sean here, and, feel free to reach out, email, phone calls. That's what ARA is here for, is to help answer questions around this kind of stuff and get you headed in the right direction and answer some of those things and maybe point you to some of those resources, or even send you some links to some of those OSHA.gov websites that may answer your question specifically. So don't ever hesitate to reach out from that aspect.
We did have a question that did come in from Ashley Polk. We have posters up around our business on how to prevent heat-related injury/illness. Is this enough to be posted around the shop, or will the written plan need to be posted around as well?
So training will have to be given on the written plan itself. Additionally, and this is kind of for every OSHA program, your employees need to be able to have access to those programs. They need to be able to, when, upon request, be able to be, access that information. It can't be something that goes in the general manager's office or the safety director's office or whoever is the person in charge of that, and then the door gets locked and well, I'll let you look at them later. No, they have to have access to those things. So as far as whether or not having those posters posted around the office, whether or not those posters are compliant is going to be dependent on, one, what the final regulation actually states, but two, what that poster states.
So that poster is probably a piece of the puzzle, but it's not the complete puzzle. Actually having that written policy and having it available to employees is a big part of it. And Sean touched on training, right?
Yep.
Not just this topic, but any topic that you have. Realize that any training that you conduct with your employees on policies, procedures, safety, etc., needs to be documented. If you're not documenting that training, it never happened. So a formal sign-in sheet that has the presenter or the supervisor's name that put on the content, the date, the address, or the business name, or etc., where that training took place. Sometimes even the start time of the meeting and the end time of the meeting is good for documentation perspective. And then make sure each employee would sign in. And the crucial part is the person, the supervisor or the trainer that was giving the information, they also have to sign that sign-in sheet at the end of it as the person, putting on the training. So there is, an official way to do a sign-in sheet. ARA utilizes that OSHA approved sign-in sheet for all of our training content that we have. Our Take 5 for safeties and other things that are offered through Rental U all have an official OSHA compliant sign-in form that you guys can take and utilize as your own. You can cut and paste and create your own with your own company logo and header and that kind of stuff. But a big thing that we often forget is anytime we're conducting training, doesn't matter how small or how short, 5-minute toolbox talk, make sure you're doing a sign-in sheet and you're documenting that training, because if you don't have documentation, it never happened.
That's some great advice.
Yeah.
We have one more question, and from Joe. Is there HIIPP established deadline date, or is that still to come?
So there's two ways I can look at this question. He might be asking, and Joe, if you want to clarify, if I misinterpret this at all, please do. But if you're asking if there's a deadline as to when this is going to be promulgated, no. Right now, it is in the SBREFA panel review period. So basically, the Small Business Administration brings in small entity representatives, business owners, and they have them read the regulations and give comments and feedback. So that's where it's at now. They're still meeting on this. So once that period ends, it'll basically go back to the hands of OSHA.
And there'll still be the public comment period that's going on in conjunction with this. And OSHA will basically make its final revisions and changes, and then they will announce when this rule will be promulgated. From that point, the additional thing is, once it's promulgated, and then this might be the other way you could look at this question, once this is promulgated, when do you have to have a heat injury and illness prevention plan in place? That'll really be dependent on what the final text says. Typically, it's probably 60-90 days is what you'll see for a transitional period, is 60 or 90 days. But again, that'll be dependent on what the final text says.
Great. All right, with no other questions that I see, what we'll be doing is, this is recorded, so we'll be sending out a copy of this if you join later. We'll also be sending out a survey for you all to submit, and give us your thoughts on this topic. And then also what other topics, OSHA related topics you would like to see, and how that, looks. And so you can also go to our Slido and, submit that code, we'll have it up. But we'll also be sending out that survey, with the recording. Any last words from Sean and Kevin?
Nope. I think that's basically it. It's pretty straightforward. I know this is probably a very informative, lot of information thrown at you. That's typically how these things go. Again, if you guys need any consultation or help, please feel free to reach out to me. My email is sean.willich, Sean.Willich@ararental.org. Yeah, that's all I got. Kevin, you have anything?
No, thank you all for your time and appreciate you attending.
Thank you.
You.
Appreciate it.